Should you go to trial on a driving while intoxicated case? Driving while intoxicated cases are unique. They're certainly unique in the fact that there's no mental state required. In other words, you don't have to have intended to drive while intoxicated or even knowingly drive while intoxicated. It's just, were you intoxicated when you were driving? But it's also the type of case that's unique because it requires expert testimony in most cases. First of all, the officers are considered experts in field sobriety tests, or they should be. So if they're not administering field sobriety tests correctly, or if they can't articulate how those tests should be administered and what those test results mean, then that's a huge weakness for the state. Similarly, if it's a specimen case, that is a case involving breath or blood, then there are going to be a number of experts. How was the blood drawn? Where was the blood tested? If it was a breath test, where was the breath test administered? It's not going to be out in the field as you might think. These are devices that are kept typically at a police station. There's typically a technical supervisor that will come in and testify about how the machine is supposed to operate. All of these pieces of expert testimony are places where the state might be weak and not well prepared in a trial setting. The other thing you need to talk to your attorney about is the consequences of a trial and being potentially found guilty. There are certainly some courts where the punishment after a trial will not exceed or is unlikely to exceed the punishment you would have received if you entered a plea. So very often the question of whether you want to go to trial on a misdemeanor DWI is a question of resources. Can you afford the time that it's going to take to get to trial? It may take 18 months, 24 months, or even longer to get to trial. Can you take a day off of work once a month, every month for the pendency of that case until it reaches trial? That's tough for most people. Can you afford the financial costs associated with a trial? That is, a trial by jury is going to cost you thousands of dollars. So can you afford the financial costs and the costs of time to go to trial? If you can, then going to trial in many courts and in many cases may present very little risk. Additionally, when you have cases that the state should win, you really have to ask yourself the question of, what do you have to lose by going to trial? I've gone to trial on seemingly impossible cases. I recently had a case where the blood alcohol concentration was 4 times the legal limit, and we won that case. No one else going into that case would have expected us to win the case. In fact, even amongst my peers, other attorneys in the community, there are very few people who have gone to trial and won in a case like that. But we did, and it was the state's case to lose. So talk to your attorney about whether or not it makes sense to go to trial in your case. That's going to depend on the facts. It's going to depend on the court, the judge, the possible resolutions if you were to lose, and obviously the rewards if you were to win. For some people, going to trial is a result of their occupation. So if you have a commercial driver's license, if you're a pilot, if you have certain professional licenses, you can't afford to enter a plea. And so you go to trial even when you know the odds are against you. We made this video in response to questions that we commonly receive, as well as questions that have been left on our YouTube channel. So if you have a question about criminal law in Texas or any federal criminal law, drop us a comment below and we'll be happy to answer that in a future video.